Hi guys, this is Erica from Gokce Capital.
Now before I begin, be sure to subscribe to our YouTube channel and turn on notifications. I was just reading about a court case in New England which rested on the legal status of a road that was used to access two different homes. The plaintiff, whose house was behind the defendant's house, contended that the road was a public road, whereas the defendants, who were blocking access, argued that the road was now a private road since their deed listed it as a discontinued public road. Now wait a few minutes because I'll give you the resolution to the case later in the video. But this is just one small example of how complicated access can get and why you, as a land buyer landowner, should never assume that your property has clear legal access just because there is a physical road in existence. But first, let's define what landlocked property is. Now, the question of access is a little bit complicated, but to simplify things, landlocked property is a piece of land that is inaccessible via a public thoroughfare, which essentially means that the road is publicly owned or that a public entity has an easement which allows the public to access that road. If the road leading to your property is not in fact a public thoroughfare, you have landlocked property. Now, does this mean that you cannot access your property at all? No, not necessarily. Fortunately, there is a way to gain the legal right to access your property, and this is through an easement. So if you've bought landlocked property and are trying to get legal access to it, here's what you should know. First, check if an easement is already recorded. Order a title search or try to search through the records yourself to see if there is evidence of an easement made in the past. Easements can be recorded in many different places, but in particular you'll want to look at your deed and your neighbor's deed, as well as any recorded deed restrictions, since sometimes when a property is subdivided and deed restrictions are created, there will be easements outlined in these restrictions. In other circumstances, there may be a completely separate easement agreement recorded. If there is no evidence of an existing easement, then you will have to create a new one, and an express easement is the easiest option. An express easement does rely on the goodwill of your neighbor, but if you are able to come to terms with the neighboring property owner, you should have your lawyer draft a written easement agreement that you can review with your neighbor and have them sign it, granting you access rights over a portion of their property. Finally, this easement should be recorded in the county where both properties are located to ensure that it is of public record. Often, neighbors will be amenable to providing easements because they understand the situation. However, they may ask for compensation. Now, if you're an absentee property owner or you're not local to the area and you don't know who the neighboring property owner is, you can use assessor records to look up their name. Assessor records will also usually have the address of all property owners. So you can send them a nice letter explaining the situation and asking if they would be willing to speak with you. Even if you find the neighboring property owner to be amenable to granting an easement, keep in mind that an easement is still a legal document, and thus you will want to have a local land use lawyer draft the easement or review it prior to having it executed and recorded. The rules regarding easements and property law vary from state to state, so it's important that you hire someone who is local to the area and understands all the relevant local laws. It's also a good idea to hire a lawyer because sometimes you may find that your neighbor is not willing to grant an easement, and in these circumstances you'll want to speak with your lawyer about your alternatives. In certain unique circumstances, you may have some options whereby you can get an easement granted by the court. Some examples of when this is possible include an easement by necessity, and this usually comes into play when your landlocked property and a neighboring property were once jointly owned. And at the time of severance, the creation of an easement to access the landlocked property would have been necessary. It's also possible that you may be able to file for a prescriptive easement, which, if you're familiar with adverse possession, is very similar to that concept. Basically, if you have landlocked property and you've been using a neighboring property for access, and your use has been open and continuous for a set time period, then you can apply for a prescriptive easement. It's also important to note that you must not have had permission to use the neighboring property for access. And finally, there are certain circumstances where you could get an easement by estoppel. This covers circumstances in which you bought a property and at the time of purchase were given false representation by the neighboring property owner that you would have the right to use their property for access. Furthermore, you relied on this false representation to make a decision to purchase the property. So as you can see, there are very specific circumstances in which each of these kinds of court-ordered easements may be granted, which is why it's important to discuss with your lawyer. But let's return to our opening story. How did that work out? Well, as part of the research into the case, the plaintiff's lawyer went back to the original conveyance deed for the neighboring property, and the deed had language that strongly implied there was a public right-of-way on the property. Thus, the court ruled that the road in question was public and could not be blocked. So in this circumstance, the plaintiff was able to prove that their property was not in fact landlocked, but it did cost a fair amount of time and money. And this is why it's important to do your due diligence before purchasing landlocked property. Do not simply assume that because there is a road that it grants you legal right. So at the end of the day, if you are in the market to buy land, always give the county or city a call to see what the legal status of the road leading to your property is. Now, do you have any stories about landlocked property? Let us know in the comments. And if you like this video, you're going to love our Gokce Land Due Diligence program. We'll make you a land due diligence expert in 7 days. Check it out at gokcecapital.com/glad. And while you're at our website, don't forget to explore our $1 down properties at gokcecapital.com/listings. Finally, if you have any questions, don't hesitate to reach out. You can email, call, or text, and we will respond as soon as possible. So thank you for listening, and more to come.